Hey everybody, John Skiba here from the Consumer Warrior YouTube channel, and in this video we're going to talk about the bankruptcy trustee in Chapter 7 Bankruptcy. But if this is your first time here to my YouTube channel, please go ahead, click subscribe, check on that little bell. That way you'll be notified each and every day when I put out new videos that'll help you deal with serious debt issues. Okay, so this is part 4 of my 7-part video series on the Chapter 7 process. This is the ultimate guide in Chapter 7. This is where we do a deep dive into each of the different parts, the paperwork, everything that's involved in the Chapter 7 process to help you to make a good decision on whether it's something that's going to help you to get that fresh start that you hear about so much when we talk about a Chapter 7. And in this video, I want to talk about one of the major players in the Chapter 7 bankruptcy process, and that is the bankruptcy trustee. Now, the bankruptcy trustee, the way to view them, sometimes when people file bankruptcy here with me in my office in Arizona, they will view the trustee as almost like the judge in their case. And that's because really the trustee is who you deal with, other than your attorney. The trustee is really the one you're dealing with most in the Chapter 7 process. A lot of people are surprised to see that they don't actually deal with the bankruptcy judge. I usually say, if you're dealing with the bankruptcy judge, something may have gone not quite wrong, but all of a sudden things are a little more complicated because the bankruptcy judge, while they do sign off on your final discharge order, they're not really involved in the day-to-day. This is more the bankruptcy trustee. So let's talk about who the bankruptcy trustee is. In each state or each district, there is a United States trustee. This person is a political appointee of the federal government, and part of their job is to appoint or to work with what are called standing trustees. These are Chapter 7 trustees. They're kind of like independent contractors to the Department of Justice, and their job is to process these Chapter 7 cases. So in the bankruptcy world, we kind of have the judge who kind of rules the bankruptcy world. You have you and your bankruptcy attorney, like myself here in Arizona, and then the U.S. trustee and the standing Chapter 7 trustees. Their job is to administer your case, to review it, make sure the paperwork's been submitted to the court. They hold what's called the meeting of creditors, which we're going to talk about in just a minute. And they look to see if there's any assets that they can seize, sell, and make a distribution to your creditors. So let's talk specifically about who, the trustees. So they get this appointment. Like I said, they're independent contractors with the Department of Justice. And the main time that you're going to be dealing with them is in the meeting of creditors. Now, in every Chapter 7 bankruptcy case, there's this thing that happens about 4 to 6 weeks after filing called the meeting of creditors. This sounds really ominous. And I can tell you, it's one of these things that people stress out about, and I tell all my clients here in Arizona, don't stress out about the meeting of creditors. It's important, but it's not anything to lose sleep over, which I realize is easy for me to say. But I can tell you this, it's a very straightforward process, and what it is, it's where the bankruptcy trustee puts you under oath and is going to ask you a series of questions. Those questions are generally pretty short. The whole meeting generally takes about 5 minutes. But they're asking you, typically, if you reviewed your bankruptcy documents, the petition, the schedules, the statements, everything we talked about in the last video, they're going to ask you if you reviewed them, if the information in there is complete, if it's correct. They're going to ask you if you included all your creditors, if you included all your assets, and if you signed off on those documents. They're going to ask you point blank, is that information accurate to the best of your knowledge? And then if they have any specific questions as to prior bankruptcy filings, if you have assets that they have questions on, if you're self-employed and you own a business, you can generally expect some questions there. And then they'll give an opportunity if any of your creditors do want to appear and ask you questions. I can tell you in most Chapter 7 bankruptcies, it is very rare for a creditor to appear at the meeting of creditors and ask any type of questions. It does happen, but I can tell you, I've been doing this over 20 years, and I can probably count on 2 hands the amount of times that a creditor has appeared and wanted to ask questions. The reason is, if a creditor has any significant questions, they typically can go through your attorney, or they can even set what's called a 2004 exam, where they have more time. One thing you're going to find out with the meeting of creditors, The court will give you a time for you to appear. You're not the only one who got that time. In Arizona, where I work, typically there is 4 to 6 cases done every 30 minutes by the bankruptcy trustee. So you can see they don't have a lot of time, and if the creditor wants to come in and ask a bunch of questions, it throws off the whole schedule. The trustees do give them some time to ask questions, but like I said, very rare. And in most cases where the creditor is going to appear, you and your attorney will probably know or have a good idea that it could happen beforehand. Now, something that has changed since COVID-19 is in Arizona, we used to do the meeting of creditors at the bankruptcy court. These meetings have now gone completely over the telephone or sometimes a Zoom call, depending on the trustee here in Arizona. I've heard in other jurisdictions that they are doing them in person. But I can tell you what I've seen from the United States trustee, that the intent was that these were going to go completely virtual nationwide. So if you're in the state of Arizona, it's even going to be simpler than before. It's a phone call. You used to have to take the day off work, go down to the courthouse, and it was a big ordeal. Now you're just having to call into a teleconference, answer the questions, kind of in, out, and done, and that's it. So what I do with my clients, because a lot of people ask, how do I prepare for the meeting of creditors? The best thing you can do is to review the bankruptcy documents, the schedules, the statements, review them page by page, go through the entire thing, and make sure that you're not missing anything. Many of the trustees in Arizona, they will ask you, is there anything that you should have included that you didn't? They'll give you a chance to come in and correct anything that you need to amend. And it's possible if you forgot a creditor, that can be amended and you can include that going forward. Or even if there's an asset. I've had clients who tell me, look, I reviewed my documents there a few weeks later. I realized I forgot that I have this thing in the garage and I need to disclose it at this point. So you can handle all that. Then, once you get through the meeting of creditors, if there are any assets that the trustee believes are not protected by an exemption in your state and have non-exempt equity in them, they can liquidate them. They can seize the asset, sell it, and then make a distribution to your creditors. Once that part of it's complete, the trustee, either they'll decide that there are no assets, which is what most Chapter 7 cases are. They'll file a report that says that there's nothing to distribute. Or if they do have an asset and there's money there to be distributed, they'll distribute that to your creditors, and then they'll let the bankruptcy court know that your case is ready for discharge. The discharge order is the final order from your bankruptcy judge that says you're no longer legally obligated on those debts, and then the trustee's job will be complete at that point. Make sure you go back if you didn't watch any of the prior videos on Chapter 7. Like I said, we're doing a 7-part series on kind of a deep dive of the whole Chapter 7 process. And then we have a few more where we're going to dive even deeper into the process to help you make a good decision on whether bankruptcy is the best option for your debt situation. Thanks for watching today.